Lesson: Ethical challenges in multinational contracts. Ethical challenges in multinational contracts present a complex landscape for professionals involved in the negotiation, drafting, and execution of agreements across diverse legal and cultural environments. These challenges arise from differences in legal systems, cultural norms, business practices, and ethical standards, necessitating a strategic approach to navigate them effectively. Ethical considerations in this context are not merely about compliance with local laws, but also involve a commitment to universal principles of fairness, transparency, and accountability. One of the foremost challenges in multinational contracts is the variance in legal environments. Different countries may have distinct legal frameworks governing contracts, which can lead to conflicts or ambiguities in terms. For instance, what is considered a standard business practice in one jurisdiction could be perceived as unethical or illegal in another. To address this, professionals must employ a thorough due diligence process. This involves researching and understanding the legal requirements of all jurisdictions involved in the contract. Utilizing legal experts or consultants familiar with local laws is a practical step to ensure compliance and mitigate legal risks. Cultural differences also play a significant role in shaping ethical challenges in multinational contracts. Cultural norms influence what is considered ethical behavior, affecting negotiations and the execution of contracts. For example, gift-giving may be seen as a way to build relationships in some cultures, while in others, it could be construed as bribery. To navigate these differences, frameworks such as Hofstede's cultural dimensions theory can be instrumental. This framework helps analyze cultural values related to power distance, individualism versus collectivism, masculinity versus femininity, uncertainty avoidance, and long-term orientation, providing insights into how these cultural variables might impact contractual relationships and negotiations. Language barriers and communication challenges further complicate multinational contracts. Misinterpretations or mistranslations can lead to misunderstandings that may have ethical implications. To counteract this, professionals should prioritize clear and unambiguous language in contract drafting. Employing bilingual legal professionals or certified translators can be a practical tool in ensuring that all parties have a mutual understanding of the contract terms. This step not only prevents disputes, but also upholds ethical standards by ensuring transparency and clarity. Corruption and bribery are significant ethical concerns in multinational contracts. According to Transparency International's Corruption Perceptions Index, many countries still struggle with corruption, which can affect how contracts are negotiated and enforced. To combat this, organizations can implement robust compliance programs that include anti-corruption policies and training for employees and partners involved in international contracts. The Foreign Corrupt Practices Act in the United States and the UK Bribery Act are examples of strict regulations that organizations can model their compliance frameworks on to prevent unethical practices. Another ethical challenge is the disparity in labor and environmental standards across different countries. Multinational contracts often involve supply chains that span multiple regions, where labor and environmental regulations may vary widely. Ethical issues arise when companies exploit these disparities to reduce costs, leading to poor labor conditions or environmental degradation. To address this, organizations can adopt international standards such as the International Labor Organization's conventions and the ISO 14001 for environmental management. Incorporating these standards into contracts can ensure that ethical labor and environmental practices are upheld across all jurisdictions involved. Conflicts of interest and confidentiality breaches are additional ethical concerns in multinational contracts. Professionals must be vigilant in identifying potential conflicts of interest that may compromise the integrity of the contract. Implementing a conflict of interest policy that requires disclosure and management of any potential conflicts is an effective strategy. Additionally, ensuring the confidentiality of sensitive information is paramount. This can be achieved through robust data protection measures and clear confidentiality clauses in contracts that define the obligations of all parties regarding information security. The use of technology in managing multinational contracts introduces further ethical considerations. While digital contract management tools enhance efficiency and accessibility, they also raise concerns about data privacy and cybersecurity. Professionals must ensure that the technologies used comply with international data protection standards, such as the General Data Protection Regulation in the European Union. Implementing strong cybersecurity protocols and regular audits can safeguard against data breaches and uphold ethical standards. One practical framework for addressing these ethical challenges is the ethical decision-making model, which involves several steps: identifying the ethical issue, considering the stakeholders involved, evaluating the alternatives, making a decision, and implementing the decision while monitoring its outcomes. This model provides a structured approach for professionals to systematically address ethical dilemmas in multinational contracts. For instance, when faced with a situation where a local partner suggests a practice that may be unethical under international standards, this model can guide the professional in assessing the situation, considering the impact on all stakeholders, and making a decision that aligns with both ethical principles and business objectives. Case studies further illustrate the application of these strategies. For example, the Siemens corruption scandal, where the company was found guilty of engaging in widespread bribery to win contracts, underscores the importance of robust compliance programs and ethical training. In response to the scandal, Siemens implemented comprehensive reforms, including the establishment of a global compliance program and the appointment of compliance officers in each business unit, demonstrating the effectiveness of proactive measures in fostering an ethical corporate culture. Statistics on the financial implications of unethical practices in multinational contracts also highlight the importance of maintaining ethical standards. According to a study by the Association of Certified Fraud Examiners, organizations lose an estimated 5% of their revenue to fraud each year, with corruption being a significant contributor. This statistic underscores the need for organizations to invest in ethical frameworks and tools that prevent unethical practices and protect their financial interests. In conclusion, ethical challenges in multinational contracts require a multifaceted approach that incorporates legal, cultural, and technological considerations. By employing due diligence, utilizing cultural frameworks, implementing robust compliance programs, and adopting international standards, professionals can navigate these challenges effectively. Practical tools such as ethical decision-making models and real-world case studies provide actionable insights that enhance proficiency in managing ethical considerations in multinational contracts. As the global business landscape continues to evolve, the commitment to ethical principles remains paramount, ensuring that multinational contracts are not only legally sound, but also ethically responsible.